Article 1507. A document of title in which it is stated that the goods referred to therein will be delivered to the bearer or to the order of any person named in such document is a negotiable document of title. But before we proceed, we must define first the most common terms used in this article. Definition of terms. Document of title to goods. It includes any bill of lading, dock warrant, kidan, or warehouse receipt or order for the delivery of goods or any other document used in the ordinary course of business in the sale or transfer of goods as proof of the possession or control of the goods or authorizing or purporting to authorize the possessor of the document to transfer or receive either by endorsement or by delivery of goods represented by such document. Goods, which includes all chattels, personal but not things, in action or money of legal tender in the Philippines. The term includes growing fruits or crops. And order, it relates to documents of title, means an order by endorsement on the documents. The nature and function of documents of title. Documents of title refer to goods and not to money. They all have this in common, that they are receipts of a bailee or orders upon a bailee. A document of title is also a symbol of the goods covered by it. It serves as evidence of transfer of title and transfer of possession. It also serves as an evidence of the contract between the parties who are bound by its terms. There are three most common forms or documents of title. Number 1, bill of lading. It is a contract and a receipt for the transfer of goods and their delivery to the person named therein, to order or to bearer. It usually involves three persons: the carrier, the shipper, and the consignee. Number 2, the dock warrant. It is an instrument given by the dock owners to an importer of goods warehoused on the dock as a recognition of the importer's title to the said goods upon production of the bill of lading. Number 3, warehouse receipt. A contract or receipt for goods deposited with a warehouseman containing the latter's undertaking to hold and deliver the said goods to a specified person, to order or to bearer. We will show you a case regarding this article. My classmate, Ma'am Grace Bation, will explain thoroughly the case.
This is Grace Bation of Group 1. My report is about the case of Saludo Incorporated versus Court of Appeals. The facts of the case. Petitioners herein, together with Pomersky and Sun Funeral Home of Chicago, brought the remains of petitioner's mother to Continental Mortuary Air Service, which booked the shipment of the remains from Chicago to San Francisco by Trans World Airways, and from San Francisco to Manila with Philippine Airlines. The remains were taken to Chicago Airport, but it turned out that there were two bodies in the said airport. Somehow the two bodies were switched, and the remains of the petitioner's mother was shipped to Mexico instead. The shipment was immediately loaded on another PAL flight, and it arrived the day after the expected arrival. Petitioners filed a claim for damages in court. Petitioners considered Trans World Airways' statement that it had to rely on the information furnished by the shipper, and that is failure to prove that its personnel verified and identified the content of the casket before loading the same constituted negligence of the Trans World Airways. The lower court absolved both airlines and upon appeal it was affirmed by the court. The issue: whether or not private respondents is liable for damages for the switching of the two cascades. The ruling: no. The Supreme Court concluded that the switching occurred, or more accurately was discovered, on October 27, 1976, and based on the above findings of the Court of Appeals, it happened while the cargo was still with Continental Mortuary Air Service. Well before the same was placed in custody of private respondent, no amount of inspection by respondent airlines companies could have guarded against the switching that had already taken place, or granting that they could have opened the casket to inspect its contents. Private respondents had no means of ascertaining whether the body therein contained was indeed that of Crispipano Saludo, except possibly if the body was that of a male person, and such fact was visually apparent upon opening the casket. However, the repeat private respondents had no authority to unseal and open the same, nor did they have any reason or justification to resort thereto. It is the right of the carrier to require good faith on the part of those persons who deliver goods to be carried or enter into contracts with it, and inasmuch as the freight may depend on the value of the article to be carried, the carrier ordinarily has the right to inquire as of its value. It is the duty of the carrier to make inquiry as to general nature of the article shipped and of their value before it consent to be carried, and its failure to do so cannot defeat the shipper's right to recover the full amount or full value of the package if lost. In the absence of showing of fraud or deceit on the part of the shippers, in the absence of more definite information, the carrier has the right to accept shippers' marks as the content of the package offer for transportation and is not bound to inquire particularly about them in order to take advantage of a false classification, and where shippers expressly represent the contents of a package to be of designated character. It is not the duty of the carrier to ask for reputation of the statement nor disbelieve it and open the box and see for itself. However, where a common carrier has reasonable ground to suspect that the offered goods are of a dangerous or illegal character, the carrier has the right to know the character of such goods and to insist on an inspection, if reasonable and practical under the circumstances, as the condition of receiving and transporting such goods. In the case at bar, private respondents had no reasons whatsoever to doubt the truth of the shipper's representations. The Airways bill expressly providing that carrier certifies goods received below were received for goods, and that the cargo contains casketed human remains of Crispipano Saludo, was issued on the basis of such representation. The reliance upon by private respondent was reasonable and for so doing. they cannot be said to have acted negligently. Likewise, no evidence was presented for transportation was anything other than what it was declared to be, as would require more than routine expectation or call for the career or insist that the same that the same to be open for scrutiny for its contents per declaration. Nonetheless, the fact shows that petitioners' right to be treated with due courtesy in accordance with the degree of negligence required by law to be exercised by every common carrier was violated by Trans World Airways, and this entitled them, at least, to minimal damages from Trans World Airways alone. Article 2221 and Article 2222 of the Civil Code make it clear that nominal damages are not intended for indemnification of loss suffered but for the vindication or recognition of rights violated or invaded. Wherefore, with the modification that an award 4,000 pesos as and by way of nominal damages is hereby granted in favor of petitioners to be paid by respondents Transport Airlines. The appeal decision is affirmed in all other respects. Thank you so much, everyone. This is Grace Bation again with my partner, Asiron Carlito.
And finally, there are laws which governs documents of title. Number 1, the Civil Code. Number 2, the Warehouse Resets Law. Number 3, the Code of Commerce. Thank you and keep safe.